May I ask those of panel 5 to make themselves known to the technician so that their microphones could be wired. And I'm proposing that we start without further delays. I know that the number here this morning is impressive, though not impressive enough, but we have to kick off. We're already 20 minutes behind time. And I'm going to suggest that maybe we kick off in the next 3-4 minutes. Okay. You did your best indeed. At least few more people are in here, so I know you did your best. Yes. We are going to kick off now, and I'm hoping that those who are still having coffee or breakfast will join us not too long from now. We will kick off in a moment, but we wouldn't do that without still thanking our sponsors and Weber Windsor for the fantastic reception they gave us last night. A few announcements which shouldn't take long. The ICA guides. Yesterday I announced that if someone took them by mistake and kept them in their bags, they should check and replace them. This morning, to my greatest surprise, they've taken a bit more away. So it means what I said was not understood, but never mind. Today is the last day, so if you can keep it for a few moments, take it back and then pick it again as we close this evening, that will be fine. Sorry? When do you pay for what? Have you taken one? Oh, you want to pay for one? There are a few books out there for sale. Which one do you want precisely? All right. I'm sure if you speak nicely to the young girls and boys outside there, they will tell you how to pay. And yeah? Okay, then, please. So do that during coffee break. You're a good man. You want to pay for the copy you need, so good man. The UCT students, please, during coffee break, make yourselves known and come out here possibly so that you could have photographs with Liz, who is very keen to have a portrait with you. And that applies to the programs committee. Members, they make their way here at the same time. Now, we carry on with the program by way of our panels, and today we have panel 5. We start with panel 5, and that is going to be moderated by Naomi Tarawali, somebody that we all know very well. And the panelists include Rose Ramo, professor, we know again very well, and Mohammed Shelbaya, a known person, Tochukwu Amir Nugu, and Agnieszka Zarodna. Please, if I have pronounced your name incorrectly, forgive me, because I am kind of handicapped in that sense. But when you have the microphone on and when it's your turn to speak, please say your name correctly and say a few words about yourself. That is part of the program. So I'm going to now invite Naomi to kick off panel 5.
Thank you. Thank you very much, and welcome to panel 5, everyone. Thank you for being here this morning. So I've been saved the job of going through the panelists. They're a wonderful group, and I'm sure we're going to have a great panel. We can just jump right into it. So this panel is to discuss the implementation of the African Continental Free Trade Agreement, or AfCFTA, particularly following the adoption of the investment protocol by the African Union in February 2023, and also ISDS and investment claims relating to Africa more generally. There's a lot to cover, and I have to say, very commendably, I think in preparing for this, the panel, we're really determined that we spend enough time talking about the implementation and the practicalities of these aspects, rather than covering sort of well-known and important but well-trodden ground. And so we're going to spend just a short while first understanding some of the challenges and issues in this area, before turning to a deeper discussion on how African states and stakeholders are evolving their positions regarding ISDS, and specifically the implementation of the AfCFTA investment protocol and the dispute resolution mechanism that's still being negotiated. So without further ado, as I said, we'll start by discussing some of the challenges, some of the issues. And so Chukwu, if I could start with you, it might be said that a number of African states are becoming a bit frustrated with the inclusion of ISDS provisions in investment agreements. Could you, give us an overview of some of the causes for those frustrations and concerns?
Thank you, Naomi. And before I start, I'd like to thank the organizers of the conference for the invitation. It's a pleasure to be here. So thanks, Naomi. I think that's a great place to start from. We all know, and we are all aware that the ISDS system has come under a lot of challenge in recent times. This is inspired by a number of factors, including the perceived deficits and the legitimacy and transparency of the system under this, and some other factors which I'll get to in turn. But under this, some of the concerns are that there's been the legitimate policymaking powers of the states have been curtailed by ISDS. Some of the factors and some complaints are with some of the provisions of older generation BITs, such as the national treatment, which prohibits states from making negative differentiations between national and international investors. You also have the FET standards, which has been subject to very wide divergent interpretations by tribunals, with the result that there are a vast array of measures that will be deemed a breach of that obligation. Some of the concerns that we have, or the African states have, with the ISDS is the huge unfavorable awards. In my view, thinking about this now, I think this is this is their major issue. When you think about it, I can really see how an African government would sit back and be told by maybe a three-member panel tribunal that they are liable for having exercised certain regulatory measures. So that is a big concern, and statistics show that.
Sorry, Chukwu, can I just interrupt? If you could speak just a bit more into your mic, I'm being told it's a bit difficult to hear.
Sorry, is this better now?
Yes.
I'm sorry. This is actually funny. The reason I was told that we were given this was for people that can't speak in the mic, and I'm still making the same mistake, but yes. So I was just making the point that huge unfavorable awards is also a concern. African states have routinely been held liable and have had to pay a very huge amount. Statistics show that the highest amount ever paid by an African country was about $2 billion paid by Egypt in the Union Fenosa arbitration. There are also other concerns, such as inconsistent ISDS awards. That's also a major issue. We find that tribunals typically there are divergent interpretations of similar provisions in BITs. And we also find that there's also the concern of erroneous awards as well. And that's a concern because, and I think the clamor really is that these tribunals render awards that are inconsistent with certain international law principles, and there's no opportunity to, sort of review those awards on the merits with a view to rendering the proper decision. Other than that, there's also costs. I think African states have also complained about the huge cost implication of the ISDS system. So that's also a concern as well. If I move on from the concerns, there's also the concern about whether or not the disputes should be Africanized, so the Africanization of disputes. And to that, it also means that whether we should have more African representation in the ISD system, and whether the disputes or the resolution of the disputes should be domiciled within Africa. So these are all the concerns, and I guess the question that then arises is how have we responded to these concerns? One thing is clear. I mean, it's universally accepted that there's need for reform of the ISDS system. The issue is, the point of divergence is how these reforms should be effective, and agreeing on the most suitable optimal reform. On the part of the states, I run out of time.
No, you're not running out of time. I just wondered whether if we sort of going to come on to talk about the reform and what we may do in response, and whether.
Yeah, I was just highlighting that. Yeah, so on the part of the states, what they have done typically is it's been divergent. It's either been a total rejection of the ISD system or its acceptance with some modifications. But that said, I imagine that the questions that are important and that would naturally arise, hopefully in the course of our conversation, would be one, how sufficient and how sustainable are these responses by the states to address the issues with the ISS system. I think another question may be to what extent can these African states do without ISDS, right? And whether there's a correlation between ISDS and FDI influence to the states. And finally, how I imagine the AfAA and its investment protocol, addresses this. I will pause here.
Yep. So lots to unpack, and maybe with that, I can ask Mohammed to sort of, having heard so you could go through all these various issues, is there a backlash against investment arbitration in Africa?
I think so. And I mean, well, let me take a step. I think there's a backlash against investment arbitration generally. It is not specific to Africa, but obviously the issues in Africa might be a bit even more acute. But the backlash is general. I mean, to give a sense of that, let's take a look at termination of BITs in the past 10 years. I don't want to get the figures wrong, so I have them here. So you have in between, so if you just take the decade starting sort of the second decade of the 21st century. So if you take 2010 only onwards, so now we're only 13, 14 years ago. The wave started with, there was some in the decade before, you had some sort of specific events for Venezuela, denouncing a few BITs, a couple of Latin American countries denouncing BITs in response to a specific event. But sort of the tide started really from 2010 onwards, and you had Australia starting by then sort of removing ISDS from its BITs, then South Africa almost immediately after in 2011 started terminating BITs, then even more in 2012, and then Indonesia followed. Italy started withdrawing from the ECT, then some later, the rest of the European Union, well, not all of it, but a lot did. Germany, France, Netherlands, Spain, Poland, Slovenia, Luxembourg. Then the EU Commission actually invites all member states a few years later to withdraw from the ECT. India denounced 68 BITs in the same day a few months ago. So the sort of the tide is there. And in fact, for the first time in history, if you look at the past 7 years, from 2016 to today, there was 285 BIT terminations. And in fact, if you look at from 2019 onwards, for the first time since the system started booming in the 70s, there is more termination of BITs per annum than there are new BITs concluded. So sort of replacement rate, if you will, is below the replacement rate at this point. So the backlash is there. Now, why? I mean, a lot of the concerns are already highlighted, so I don't want to repeat them. But I think two concerns that are especially relevant for Africa. They're relevant for everywhere, but they're especially relevant for Africa, relate to one, sometimes there's perception, and that perception sometimes is numerically verified, that there is a bit of detachment between the investment treaty awards and the reality on the ground. So let's take corruption as an example, right? If you look at the last 20 years, exactly 20 years, or 2020, 2003 to 2002 to 2023. In those 20 years, there was, again, I don't want to get numbers wrong, there was 177 awards involving Africa, investment awards, be they exit, whatever. Well, the ones at least we can track. But that gives you a sample, right? 177 cases in 20 years. Of those 177 cases, corruption was alleged in 20 of them. So that's what, 11.3%? Corruption was found in two. That's a 1.13%. Now, if you accept that that's reflective of reality, you would have to accept that of a sample, of a sort of a random sample of economic transactions in the continent, only 1.13 involved issues of corruption. If you follow any NGO reports on the matter, you'd know that that number is far from correct anywhere in the world, and not in Africa either. So it's clearly some underfinding of corruption that's going on, and therefore a detachment from the reality. And when people see that, and in fact, you're starting to see some, France, for example, almost never sets aside awards. It's after Geneva, it's probably the hardest jurisdiction to set aside awards. In the past 3 years, there is one award related to Africa set aside for reason of not finding corruption per year. There was one against Libya in 2021, set aside by the Paris Court of Appeal, one against Gabon in 2021, and another one against Gabon in 2022. So that's a very, very high number, again, of setting aside for France. Another reason, and that is also, again, not specific to Africa, but especially acute here, is the unpredictability of the systems. There is the problem with the standards, how they used to be drafted in BITs, is that they are somewhat inherently idiosyncratic. Fairness is almost like beauty, a little bit in the eyes of the beholder. So if your standard is just FET, fair and equitable treatment, whatever, then that opens up a lot of room for idiosyncratic assessments, which with it brings room for a feeling of things are not being treated like for like. So let's take very recent cases. Let's take just the last 2 years. There was KCI versus Gabon, and you had Silver Ridge versus Italy. Now, in KCI versus Gabon, the question was, there's a construction contract between the state and a construction company. The works were done, part of it were invoiced, and the question was, are the amount payable or not? The state sits down with the investor, they decide they want the invoices have problems and they need a new economic model. The parties try to agree a new economic model, but they fail to agree. And that failure to agree was considered by the tribunal, who noted that the invoices were defective, they were too high, they were irregular in form, but because the state didn't respond to the requests so just the failure to respond by the state qualified as a breach of FET. Now contrast that a year later to Silver Ridge versus Italy. Italy adopts a renewable decree that says, if you come and build a renewable plant, a renewable energy plant, I will give you a preferential tariff for 20 years. Somebody comes, they build the plant, they get a tariff for 20 years, they get a contract for 20 years. Then 5 years later, Italy comes and says, I can't afford that tariff anymore. I'm reducing it by 8%. Obviously, the investor goes and says, that's against FET. The tribunal says, hold on, no. Even though the contract said 20 years, it's not really a guarantee of stabilization of 20 years because as an investor, you should have expected that the regulatory framework might change, even if you're told it's 20 years, if the general interest required that. And unless the change was so drastic, and here the change was not drastic. Now, don't get me wrong, that is the right outcome. But that's not the outcome we're seeing in all cases. So it's that idiosyncratic sort of approach that leads to uncertainty. You can never know if you're going to get a Silver Ridge-like tribunal or a KCI-like tribunal. And that idiosyncrasy also helps in sort of fomenting that backlash.
Yeah. I'm going to come back to you, Mohammed, on sort of how we see some responses to that, but I just want to dig a little bit into some of the points that have been mentioned. And Rose, if I could come to you on the sort of mega giant awards that Tochukwu mentioned, and get your thoughts on what some governments have done constitutionally or in their domestic laws to try and sort of respond or sort of react to that.
Thank you, Naomi. Thank you, SG and VP and all the board for having invited me. So it's my first time in Cape Town. Last time I was in South Africa was about 25 years ago. So it's nice to be back in South Africa. Because the question you asked, Naomi, really deals with going back with what my co-presenter mentioned was governments in general, it's kind of weird to see a tribunal, 3 members, and we know the history. Things have changed now. Before it used to be, the tribunal is not diverse, and then all of a sudden you have this $10 billion, and we have some of the awards in the case of Nigeria, that's like 20% of Nigeria's GDP. So Africans in general, it shocked the conscience. And I think going back with what Mohammed says, before we even started to withdraw from those BIT in the case of South Africa, I think African governments, they have tried to mitigate the harms. And one way is through their legislations, even constitutional amendments. We see that, for instance, in Ghana, if an investor comes and sign a contract, if the contract did not go through Parliament, even when in cases of foul Atlantic, which is a case in Ghana, even when Ghana has benefited from the project, and when the case gets to the Supreme Court, it can say, hey, sorry, it's not a valid kind of contract because it did not go through Parliament. And one thing I have to mention, this really, when you think about it, it deals with the a country's sovereign right. And I have to mention, I don't want to do an international law course here, but when you look at usually when you're looking at economic law and you look at the UN General Assembly Resolution 217, which basically says that the will of the people shall be the basis of the authority of the government. So in a sense, under international law, the people's wills will imply that the notion of the self-determination and the government has to act as trustee over all these management. So I think that's what African governments, they have tried to do in a sense. And I have to step back a little bit and say, we see similar constitutional provisions for Kenya as well. But it has more like a check and balance in terms of what the government can do. And going back with what my co-presenter says, like the awards, they are unfavorable, and it also undermines the government's right to regulate sometimes because the government is trying to do the right thing using its sovereign rights. So let me pause and say, with that factor, looking at the legislation, I want to brag a little bit about Nigeria. Nigeria just has a new law, and I'm saying this really because if you look what Nigeria tries to do, the old law is it's a 35-year-old Arbitration and Conciliation Act of 1988, and which was repealed and replaced now by the new Arbitration and Mediation Act. So the new act actually is based on the revised UNCITRAL model law, which was adopted in 2006. And we see it improves the legislative framework for domestic and international arbitration in Nigeria. It strengthens Nigeria's position as a leading authority in arbitration in the continent. And when I review that law, and I would say, make no mistake, in my view, and I will invite you to comment if we have time, that this is some kind of law that's going to resist, to borrow your word, ISDS large awards, especially if the parties choose the seat to be in Nigeria. And also, if you have in your contract, or you choose the law of Nigeria, because if you look, for instance, under Nigerian law, third-party funding was not permitted. This now new law says that it's okay, and they've abolished the tort of champerty in relations to arbitration proceeding and arbitration related court proceedings. Then you have the idea of defaulting the 3 arbitrators. Now you have 1, just as under the UNCITRAL. So the new act brings Nigeria framework into in line with the global practice and consistent with model law. So you have other things such as the emergency arbitrator, but what's really, really important to think about is the revolutionary aspect of the award review tribunal. I know that there's been a lot of criticism on that, but that's my favorite part. And let me explain. The new act will allow the parties to have the award reviewed by an award review tribunal under Section 56. What is that? Assuming that you have an arbitral tribunal of 3, like you said before, those 3 individuals who award, I don't know, $10 billion, and they think they're home free, they're going home. There is an opt-in provision where the losing party can say, hey, I want a new tribunal to review this award. And what it does, the new tribunal will review this award and can decide, can make a different determination. The award review tribunal is like a court, and it will set aside the award in part or in whole, and it's quite interesting.
Yeah.
So therefore, you're not going to have those big awards like you used to before, if you have such a review. And it's expected to render a decision within 60 days. And the court will have the power, if you go back to court, you can go back and forth. The final stage, the court will have the power to reinstate the award and set aside the award review tribunal, and if its decision is not supported. So it's really, really interesting. The other aspect that you mentioned earlier is cost. We know that in international arbitration has been very expensive. And again, I'm going to brag about this new law. Is in Section 50 of the Act. The key objective is to reduce the cost of arbitration. What it does in the new Act, it makes important intervention in relation to the cost of the arbitration proceedings in Nigeria and also international arbitration. And it has something that is similar to ICC, because the mandatory for the tribunal fee has to be reasonable, and the arbitral tribunal must fix its cost of the proceeding in the award. That's a ICC specific. And the tribunal is especially required to take into consideration its own fees, expenses, costs of the expert, etc. So this is very crucial for both domestic and international arbitration, and because it will focus on a fair resolution of the dispute, and it has to be reasonable. So when it comes to legislation that countries, African states are doing right now to mitigate the harm, I think this is a very good example, and Nigeria has been victim of those large awards.
It's very, very interesting, and it's going to be interesting to see how that plays out and how other countries may follow. Just before we leave this sort of question of discussing some of the issues, Agnieszka, let me just come to you briefly to discuss. Tochukwu mentioned and Rose mentioned as well in the description, sort of participation and representation of Africans, Africanization. We heard a bit about this yesterday in some of the sessions, but I just wondered, is there something to add here on discussing the challenges?
Sure. First of all, I would like to thank the organizers for the lovely invitation. I'm very, very pleased to be here. To come to your question, it is trite to say that public international law specialists and international arbitration specialists from Africa of African descent are underrepresented when we look at investment arbitrations. And yes, we discussed this yesterday. Diamana Diawara made a lot of good points in her mini keynote. Touched on it in a larger context of international arbitration. I would like to focus on investment arbitration in particular. So we all know the statistics, which are not great. When we look at exit cases, and I will use exit cases as a proxy for the larger pool of investment arbitrations, we see that while there is some 15% of cases brought against African states, there's only approximately 5% of arbitrator appointments going to African arbitrators or arbitrators of African descent. Now, that's a big discrepancy. And of course, when we look at, say, numbers for Western European countries or North America, that looks very different. But when you look at even regions such as, say, South America, we can see that, say, just last year, there were 18% of cases brought against South American countries, but also 18% of arbitral appointments went to South American arbitrators. So there can be more balance. So question is, does it matter? I think there's no one in this room that would say, that will argue against the fact that diversity of geographical diversity of jurisdiction, of culture does not matter in investment arbitration in particular, given how important these cases are to nations. As Rose mentioned, the extent to which a nation can be touched by a large award is of interest to the nation at large. So there is a variety of initiatives to fend against and to try to diversify the pool of arbitrators. And obviously we can mention the African Promise Pledge by Dr. Emilio Onyemi, which incentivizes practitioners, individuals and firms alike to commit to appointing African arbitrators. More is needed, absolutely. And I would like to make 2 points that go specifically to investment arbitration. One is that African states should make the best use of the available tools that are already out there. And here I mean appointing individuals to exit arbitrator and conciliator panels. Those panels are where exit itself uses to appoint arbitrators for institutional appointments. So it's important that the pool is representative, is broad. And we see that some states don't quite make best use in that you can appoint 4 individuals for arbitrator panel, 4 individuals for conciliator panel for a period of time. These are not always filled in. The positions are not always submitted to exit at all times. Second, some of the nominations don't really go from African states to their own nationals or nationals of other African states, but rather to individuals who are, fair enough, very well respected, but are coming from already well represented jurisdictions. So no one will argue that these individuals would not do a great job, but if the goal is to diversify the pool, this is definitely not helping. Second point I would make is that the states should make the best use of their appointments or appointments to the panels, because oftentimes the most important part of appointing an arbitrator or choosing an arbitrator is for them to be impactful, for them to be able to carry their opinions and views with the tribunal at large and with the chairperson in particular. So here again, I will dial back to the issue of public international law specialists. And there's so many fantastic specialists in this room and coming from African countries at large. And I feel that they don't always get those appointments. The appointments, when they are coming to African arbitrators, sometimes go to persons who are absolutely fantastic, have fantastic standing as it comes to domestic law, but not necessarily are well versed with international law. And here lies the issue that their views will not always carry as much weight with the tribunal at large as it could have otherwise if they were well respected for their PIL specialism. So those are the points I will add to our discussion.
Yeah, some valid points there, but I think we spent a lot of time, enough time at least, laying the groundwork on the challenges. Let's move on and talk about the response to all this and implementation. And Mohammed, I said I would come back to you, and I'm going to. So tell us, what are states, tribunals, what is being done about these perceived problems with the ICS system as it stands?
Well, I think, different actors did different things. So let's start by states. States took, other than just saying, I'm out of the system anyway, some did that. Now, how sustainable that is, ultimately, we still need FDI in Africa. And I worry sometimes that if the solution is to say, I'm not going to have a BIT altogether, what will happen is for those concessions for which we need foreign capital, for those big projects for which we need foreign companies, these companies will negotiate in their contracts protections that are even worse than what would have been in a BIT. It's almost usually sometimes to have the collective bargaining power of a BIT, and you say, you know what? No, you have the BIT to protect you. The contract is just a contract. Because I see that. You see that in mining contracts across the continent. You see that in oil and gas concessions. You see that in EPC contracts. When there is no BIT, the foreign company comes and dictates terms. Right? So it may be best, rather than to withdraw entirely from a BIT, rather to remove an ISDS provision completely from a BIT, is to make the BIT just a bit more rational. To essentially say, okay, fine, here's your BIT, but I'm going to have a more balanced one. And we see that South Africa adopted a new model BIT in 2013, I think, if I'm not mistaken. Then that, and it's actually not just an African tendency. The EU adopted a drastically different model BIT in 2014 that is much more balanced than previous BITs. That was followed sort of across. There is a Pan-American investment code that's also much more balanced than previous generation BITs. So states have adopted new generation of BITs to replace the older one. And those new generations tend to focus on many things, to improve many things. But I'm going to give you just a couple of examples. One is what used to be sort of the bête noire of the old system, the FET, the Fair and Equitable Treatment Standard. The new generation of treaties tend to not leave it as such an open-ended idiosyncratic test, but to really narrow it down. And we see that going from the, say, EU model BIT from 2014, which limited FET to very limited grounds. There's no, the FET had come to be, if you breach the expectations of the investor in any way, you're under risk of being in breach of international law. It restricts it much more to manifest arbitrariness, denial of justice, abuse of due process, but manifest abuse of due process, manifestly wrongful discrimination on manifestly longer grounds. So very limited grounds, and even legitimate expectations, that creates a much more narrow test for how do you protect legitimate expectations. They need to be specific to the investor, they need to be expressed, they need to be relied on when making the investment, they need to have been frustrated actively through discriminatory or otherwise means. So it's a very much more restrictive test. And you see that carrying over all the way now to AfCA, but we're going to get to AfCA, but which has completely removed FET and made it something much more closer to what used to be FET under customary international law about 100 years ago. But we'll get back to AfCA later. You see it in standards like FPS for full protection and security, which had grown to include things like what FET covers. So essentially what's called protection of legal rights. And now almost all BITs, there are very few BITs that still would include full protection and security for anything other than what it is, physical security, and understood as a reasonable means obligation. State cannot guarantee security. If you're in a revolution or in a civil war or in financial crisis, you're not going to have the means to guarantee a result. All you can guarantee is that you'll do your best in view of the circumstances. And then finally, sort of in my view, what is the real sort of difficult aspect of investment arbitration, which is multiplication of proceedings. We have a contract between A and B. B is a state and A is an SPV owned by investor. That SPV is owned by a shareholder, which is owned by a shareholder, which is owned by a shareholder. All of these shareholders belong to states that have bilateral investment treaties with that state. Problem happens under the contract. What happens? You get an ICC arbitration in London or in Paris under the contract by the SPV. You get a first BIT arbitration by the direct shareholder, a second BIT arbitration by the indirect shareholder number one, a third BIT arbitration by the indirect shareholder number two, and so on and so on. And you ultimately have 4 tribunals adjudicating the same matter. It's not hypothetical. This happened. This has become now rather systematic. So now you have BITs telling you, no, you can't do that anymore. Because tribunals used to say, but hold on, these are different persons and different legal bases, because each BIT or the contract and the BITs are different legal planes. So the triple identity test is not met. So it's okay. You can proceed with all arbitrations. So now the new BITs came and said, no, you can't do that. You have to have a waiver. First of all, you have to stop all proceedings by all shareholders and the SPV to start one proceeding under any of them. That's the CETA model. And sorry, the EU model, and you can see it in the EU Singapore FTA of 2014, 2018. It's a good example of that. And you have to give a waiver. And a waiver, again, it's not limited to proceedings under this treaty. It's regardless of identity of parties, regardless of identity of legal basis, it doesn't matter. What matters is it's the same facts and the same economic clause. Okay. The point of these provisions is to preclude, and we can talk about them for hours, but I mean, the ultimate point of all of these provisions in this new generation of BITs is to say, you cannot initiate 2 proceedings in respect of the same facts and the same economic loss by hiding either under different legal instruments or behind a separateness of legal personality that are ultimately in the same vertical chain of shareholding. So that's sort of what treaties are doing amongst it. But to also have a positive sort of, it's not just a legislative change. There's also, we see it in practice, a change in how African states are handling the process. Handling the process when it's there. So more and more you have African states that have within the government specialized units that deal with international disputes, that engage international counsel, that coordinates, and because they're specialized, they understand the process better. They know who to appoint better, goes to appointment. They know how to gather evidence better for the purposes of the arbitration. They know how to, if you look at the history of ISDS, many cases ultimately have turned on the fact that the states probably was correct, but just didn't have the evidence to prove it. That handling evidence, finding it, marshaling it through different various state entities, bringing it to the tribunal is not an easy process when you're a state. And especially if you're in a state of civil war or in a state of unrest or revolution or what have you. So states are getting better at handling the process. And that's probably to me the most encouraging part of it, that even getting better at foreseeing the process and trying to prevent it ahead. So in many instances, purely commercial matters have gone to investment arbitration because of how the structure of certain state-owned entities work. It tends to transform into sovereign, that is with purely commercial, right? Because you have a public entity that's really, it's a company, it's an energy company ultimately, or electricity company or a mining company, but it is under the supervision of a minister, and you have all of these rubber stamps by different government officials. So mere commercial decisions become sovereign acts and therefore become subjected to international law for no reason. And states are getting better at saying, no, I'm going to conduct my regulatory capacity through regulatory means. That's good. but I will sub-delegate my commercial activity, because states will have commercial activities, to companies that I'll own, but that run like companies. And that sort of minimizes the risk of attribution, minimizes the risk of transforming commercial disputes into investment disputes. And you see states doing that more and more in the region. Not as quickly as one would hope, but it's there. At the beginning of it is still there.
Yeah, it's really interesting to see almost these dual tracks of the sort of, the treaty change and then also how states are evolving in responding and foreseeing, as you said, some of these claims. You started to go towards the AfCFTA, Mohammed, and I think Agnieszka, maybe we can go there now. Is that an example of sort of the states taking back control of this kind of investment instrument? How do you view that?
Absolutely, and Mohammed has nicely set out the backlash against investment arbitration, and I think a good point to make is that it's been around for a while now. I think Michael Weibel's seminal book on backlash against investment arbitration came out in 2010, so over a decade ago. By now, it would be a teenager if it was a person, soon enough able to drive, and we would be still discussing, how to deal with this and whether there is a backlash or not. I think that by now it's very clear that there is backlash and there are ways to go about it. And I think that what is interesting is to see that somewhat of a switch, because for the longest time, the backlash was largely focused on states saying how they think, how they see the existing treaties should be interpreted, and then in turn expressing disappointment when tribunals would find differently, that they would find the opposing interpretation of a treaty to be prevailing. Now, against that background, as you, Naomi, said, the AfCFTA's protocol investment is a great example of states taking back control, putting themselves into the position of masters of a treaty, as they should be, and precisely doing what Mohammed was preaching just a moment ago, talking about finding those criticisms and addressing them one by one, making the treaty more clear, more precise as to what the intent of state parties is. So African states have done absolutely fantastic job. When you look at the protocol on investment that was adopted earlier this year, you can see pretty much everything that Mohammed said is there. You look at the standards of protection, there are fewer, much more defined. There's definitions, there's exceptions, there's carve-outs. If you look, say, at national treatment, you have precisely defined what are the like circumstances that will be taken into account. When you look at right to regulate that Rose has mentioned before, it's there, it's quite well, it's expressly provided for, it's expressly stated which parts of right to regulate should be taken into account. And another important point is there's obligations imposed on investors. That is something that has been discussed for a while as missing from investment treaty regime. And now the protocol investment has it. And it's very interesting. It's going to be very interesting to see how that will be implemented. Is that a basis for, say, the counterclaims for states to start bringing them more successfully than they have attempted to date? Obviously, we don't quite know yet because the annex on disputes is not yet negotiated, not yet in place. But certainly, I would say that this is a prime example of states taking back control, negotiating and putting in place what really is important for the African nations for the future, to ensure that the goals of foreign direct investment are promoted and are delivered on without sort of down the line complaining about the tribunals taking over the control on how the treaty should be interpreted, what the terms mean, what are the obligations, how far FET, for equitable treatment, is going or not going. So definitely, I would say that that's absolutely fantastic and subscribes to the point that was made yesterday, I think, by Suzanne Rattray, that precisely the system should ensure that the goals of African nations are legislated for effectively, so that there's no uncertainty about the terms and about what the states meant, and they are not told by the tribunals. And again, as we discussed, there's issues with appointments of arbitrators, with diversity, with the outlook that is coming from African countries as to interpretation and international law and positions under that. Another tool that I think is quite important to mention is the ability of the Assembly of Head of States, the highest organ of the African Union, that will be able to issue authoritative interpretative statements. And this tool has been used in the past very effectively. For example, if we look at the NAFTA cases, the North American Free Trade Agreement, there has been one particularly glaring example of the FTC, the Free Trade Commission, which is counterpart to the Assembly under AfCFTA, issuing back in 2001 an interpretative statement with respect to a minimum standard of treatment and how that should be interpreted. So I'm quite curious to see how that will be implemented, especially given that the FTC under the NAFTA, that was 3 states. Here we have all the many states that are parties to the AfCFTA, and the statements will be issued by consensus. So I think that might be quite a long road to reach that one. And I see that Mohammed is already has views, certainly, that I will be eager to hear. But certainly that's a tool that, again, could keep the states in control that they have taken back.
Yeah, it's going to be, I mean, we're getting towards this question of implementation and how is it, what is it going to look like? And so we have all those substantive features in there and you've taken us through those. Tochukwu, let me come to you about the dispute resolution mechanism, because, that's not final. It's not, you had a blank page and they said to you, Tochukwu, you can write the dispute resolution mechanism that you think is best going to sort of improve the future of investment claims on the continent. What do you think it should look like?
That's a good one. I think let's start from what we know. So we know it's been negotiated and we are eager to know what the final outcome would be. We also know that there's a number of recommendations. People have recommended state-to-state dispute resolution mechanisms. Some states have recommended and have started practicing the resolution of these disputes and through the domestic courts. For me, right, when we talk about dispute resolution mechanism, what comes to mind and how for me it should be assessed is whether any particular or chosen dispute resolution mechanism satisfies, some of the factors that make for a good dispute resolution mechanism. And what are they? Whether there's a stable legal framework, which for me, the AfCFTA does, as Mohammed Ahmadinejad has very, very beautifully summarized. The AfCFTA, precisely defines the obligations of both investors and the state parties. What else? Impartiality, neutrality, expertise, right? Having a thorough knowledge of public international law and its concepts. And for me, when you look at all these factors put together, it just points to one thing, and which is the ISD system, but with some modifications that will take into account some of the challenges that we identified during the course of the trial, and which Mohammed has also very beautifully summarized as well. So namely, perhaps migrating to modern BITs that would ensure that there's a balance between the interests of the states and the interests of the investors. Modern BITs that will also ensure that it precisely provides that the state shall have the power and the rights to regulate, and certain regulatory measures will be exempt from liability under the ISD system. So I guess the short answer again really would be if I were to choose, I would say the ISDS system with some modification because that satisfies in great part satisfies all the factors that make for a good dispute resolution mechanism.
Yeah, and Rose, let me ask you, it's not a yes or no question, but I feel like we're tiptoeing around it. Mohammed kind of mentioned it. The sort of dispute resolution section that's being discussed kind of tiptoes around this as well. But can African states, could we survive without ISDS? What if we just scrapped it and went that way instead?
Before I answer that, I want to go back a little bit to a few things that Mohammed and the presenter mentioned.
Sure.
When you're talking about, I always highlight the fact that Africa, okay, is leading, it's pioneer with when it comes to the idea of sustainable development, which is the new generation BIT that Mohammed has been describing. We know that it started back in 2012, this country, with the SADC and the way they modified the MFN provisions. And we know that the FETs are removed because of all this backlash. And also because we've looked at the awards that are so inconsistent, like my co-presenter stated earlier. So all that, and in 2020, what we saw happen is the Netherlands BIT, model BIT, that kind of like bring back what the Pan-African Investment Code has already established in 2015. The Pan-African Investment Code is very clear, and that's why I believe in my recent paper when I said that the protocol, the negotiators should follow what was already said in the Pan-African Investment Code, and I believe they did. When you look at it, like you said, and everything step by step, how it was determined and how states now can regulate. And we still have a few things we would like to see happening would be the dispute resolution. But earlier, Mohammed mentioned that how the European Union, France, and he mentioned a lot of countries, and we have a case like AfAA, and we have also, you mentioned the USMCA, which is the US, Mexico, Canada. And we know that in 2020, what they did, they eliminated NAFTA Chapter 11. So if the United States now is saying that Canada investors, you cannot come and sue us anymore, just like France, the European Union said, we cannot have ISDS among us because we are brothers and sisters or cousins. I believe African states are trying to do the same thing. So to answer your question, can we do without ISDS? Probably yes. And as Mohammed said that it seems like we're going backwards, and it may look as so, but in the long run, if you look at the investment protocol, it's saying that, well, we're not even sure about arbitration yet, but guess what? We can negotiate, we can conciliate, and there is a term, there's like 6 months, or I forget exactly how many months we have, whether it's reasonable or not, but it's there in the books. And I think that African states, they want to have the opportunity to develop their own law. And going back to the notion of public international law, I have to say that public international law is being taught from the Western perspective and not from the global South. So now by having more African experts, and I know they exist, they're all over here, and we are going to be able to make our mark in this new world order to say that Africans' union law is actually part of international law and it should be respected as well. So we can do without it. It depends on whether each state will support one another into developing our laws the way it should be. Doesn't mean we're not going to have arbitration. As you know, the AfCFTA is intra-Africa, unless you're going to have a vehicle, like you were talking earlier, to be able to benefit. And we see some of these laws. Sometimes you can have a company coming into the country, casing the country, knowing that your law is not too shabby, but they are happy to come. Just a few years later, they come with 4 million. Now they're seeking 10 billion. And you have those famous arbitrators who are sitting there entertaining those kind of lawsuits against the state and let it go. So it looks a little bit uncomfortable. And I think African states are saying no more.
I have to say, Rose, that I have asked that question before in different forums, and I hope someone was writing down what you said because I've never quite had that perspective on it. So thank you for sharing those thoughts. So now let's move and really start talking a bit more about the implementation and how this protocol, what does it do? Why are we excited about it? Why are we interested in it? And start by hearing some sort of general themes on that from Tochukwu and Rose first, and then go on to the sort of implementation mechanics, if I can put it that way. So Tochukwu, this protocol harmonizes the investment framework. We've heard from Agnieszka as well about some of the substantive provisions. How do you think this influences the future of investment claims, disputes, investment in general across the continent?
Well, so the way I view the protocol, I see it as, for one thing, it would lead to an uptick in FDI influence into Africa. So there will be more investment, intra-African investment. And I think some study has been done to show that there would also be an uptick in investments that flow from outside of Africa. And that's with respect to investments. But with respect to investment disputes and investments claims, I think that what the protocol will do and what we hope it will do would be that it will make for a more efficient dispute resolution mechanism for intra-African investment disputes, right? And why do I come to these two conclusions, which is namely again, an uptick in investments and a better dispute resolution mechanism that addresses some of these concerns we've had. I come to these conclusions for many reasons, and some of which have been said by Mohammed and Agnieszka. So when you look at the protocol does harmonizes the investment framework in Africa. In doing this, it first of all balances the interests of the state parties and the investors by, on the one hand, recognizing the right of the states to regulate, and on the other hand, still guaranteeing some of the substantive protections you would typically have. And so that would include freedom against expropriation, the most favored nation treatment, national treatment, and of course, as Mohammed points out, the very controversial FET standard has somewhat been deleted from the AfTA protocol. And in its place, you have what they call the administrative and judicial treatment standard, which is more precise and stipulates matters that would, factors that would, become a violation of that obligation. And so for me, that's on the one hand. So that's that precise definition of the standards, the obligations, and that balance between states and investors is one factor. Another thing which is closely related to that is the fact that the protocol, as Agnieszka mentioned, is very precise. So the exceptions to various standards, they're also very, very precise language. So I'll give you an example. I would use the provision on expropriation. So first of all, the protocol recognizes specifically and expressly that indirect expropriation. And when you compare it to what you have in older generation BITs, you see that while older generation BITs focused on the consequence, which is the loss to investors, the protocol and newer modern generation BITs focus on the quality of the measure, right? And so things like the duration of the measure, character of the measure, the intent behind the measure would all be taken into account in determining whether or not expropriation is called. So, I mean, I'll move on very quickly from that. But for me, that's those precise, the precise drafting of the protocol, contributes and would ensure that when you eventually get onto the other side of the dispute or dispute resolution, the tribunal will be guided by this, and to make for a better, overall better dispute resolution process. Finally, as we would know, I think that there are about over 500 BITs among African states, and out of which about 173 there are about intra-African BITs. And so the protocol has now come. So there's bound to be really, overlap, across, BITs, across regional treaties. And so the protocol does something which is very, very good as well, which is it seeks to maybe seeks to merge as we are and harmonize, these, various instruments. I'll put it that way. So on the one hand, the protocol provides for determination of existing VITs within 5 years. There's a prescription against African states from entering into new VITs. It also says that the regional treaties should be harmonized, and for VITs with third parties, they should also, in renegotiating those VITs, they should ensure that it conforms with the protocol. So for me, I guess when you look at all these things holistically, I think there's some hope. There's some hope. Investors will still feel confident to sign their investments within Africa. African investors in Nigeria will be confident to go to South Africa, to come to South Africa and set up shop here with a guarantee that his investments will be protected. So I see a lot of promise. I guess that's the summary of all I'm saying. I see a lot of promise, and I think the only implementation, as you know, would I say setting the standards, or we're really big on having instruments or enacting instruments. And where we have a deficit and the actual implementation of this instrument. So all I've said really would apply if the protocol is effectively implemented.
Yes,
Yeah.
and I think if the panelists don't mind a slight change to advertised order, I think one of the last points you made was about harmonization and the existing framework. So maybe I could pick that up with Agnieszka and then come back to Rose to round off the panel with a discussion on the implementation aspect, which I know is something that there's a lot to say about. So Agnieszka, what do you think about how this is all supposed to fit together?
Before I answer, I just wanted to endorse Rose's point about the issue as to whether international law is really international. And I cannot agree more with that the Global South views on public international law are not necessarily the same as what is taught at major universities, and then is sort of like presented to the world at large that this is what public international law is. And there is a nice book that's basically presents that idea in more detail. Is international law really international, by Antia Roberts? So I can't agree more with that. Now, zooming a bit more on what Tochukwu touched upon, being the coexistence of the existing BIT regimes across Africa and the AfCFTA's protocol on investment. As Tochukwu rightly mentioned, the protocol does not come into the void. There is a network already that connects the various African countries with the bilateral investment treaties. And there is around 50 such treaties currently in force. But interestingly, there's 3 times more. There's around 130 agreements that have been signed between African states, but have never been ratified. And that creates already a bit of uncertainty in that the BITs I signed, not ratified, not in force. There has been at least one case where an investor brought a case under such treaty, not having realized, and it was only raised by by Mozambique, that actually the BIT has not entered into force and therefore cannot be relied on. And as a result, the case was dismissed for lack of jurisdiction, rightly so. But that causes some tension already in the existing regime. And many of those existing BITs naturally include provisions providing for investment arbitration. And there has been around a dozen of cases brought by African investors against African states. And there's a growing trend that you can see, slightly sort of mounting numbers of such cases. Now, we've just talked that the annex to the protocol is not out yet, has not yet been negotiated, and definitely not finalized. But there is a question regarding the relationship between the existing investment treaty regime across Africa and the protocol investment and the annex that is yet to come. Now, coexistence of various treaties, investment treaties, is not a new phenomenon. You can see it across the globe. You have your Energy Charter Treaty, but you also have bilateral investment treaties as between ECT member states. So there's ECT, but there's also the UK-Uzbekistan BIT, for example. There you have the DR-CAFTA, the Central American Free Trade Agreement, but you also have the US-El Salvador BIT, both of which countries are parties to DR-CAFTA. So it's not by any means new. And yet, is that a great solution? Well, and that again, I would circle to something Rose mentioned, being the intra-EU issue with the BITs concluded as between European Union member states, because that's where the clash, the potential clash between the regimes came to head most vividly. There has been a large number of BITs concluded as between EU member states. And at some point, when especially the Eastern European states became EU member states, the issue arose as to whether the existing EU law regime in place allows for cases to be brought under intra-EU BITs. The states were saying no, there was a whole big debate. European Commission had its position. It's been going on for well over a decade. And only there was ACMEA, there were Comstroy, there were Peel Holdings, a number of judgments issued by the European Court of Justice, not necessarily followed by ISDS tribunals. And finally, I think the issue was put to an end only in 2020, after more than 12 years, I think, since the issue started percolating through the system, with the agreement on termination of intra-EU BITs that was concluded as between EU member states. So to get that long story short to a positive point is what Tochukwu mentioned, that CFTA already provides for that. It has an article stating that the intra-EU BITs shall be terminated within 5 years with sunset clauses, and no new BITs as between African states shall be concluded going forward. So I think that that's a fantastic point, a very smart solution. There's no need to create a 12-year-long wait until we know what to do. However, the interesting point will be to see how that will be implemented. There's a 5-year window for those intra-African treaties to be terminated, and we shall see when and how that will happen.
Sorry. So as you can probably tell, our time is coming towards an end. But maybe we've been granted a few minutes, so maybe we can round up, Rose, with, we've heard it's only going to work if it's implemented. So we have the benefit of your academic background as well on this panel. How do we prepare our lawyers for this? How do we make sure that this thing actually does the good that it's intended to do?
Thank you, Naomi. I think this question should have been first. Because we mentioned earlier, my co-presenter here rightfully stated that in Africa and many in other lesser developed countries, we seem to put a lot of things on the books, but we don't seem to be able to implement them. And going back with what Anishka says with regards to public international law, number one, I think that it's very important that we recognize the role of lawyers. We don't have much time. I can't do this in the allotted time, but I'll quickly go over a few things. The AfCFTA is based on the WTO model. So it would help us in the academic setting. For instance, when I taught in Ghana, the only time I heard of African Union law, that is if you were doing human rights. It shouldn't be like that. I believe that the universities should have a specific curriculum to actually teach African Union law, because most lawyers that I know, they don't even know how this thing works. And you have lawyers who are outside of Africa, they are the experts. of course, they have helped drafted so many of these things. So that's why when we have disputes among each other, we don't tend to hire a firm within Africa, we go outside. So we're talking about the diversity. If we want this thing to really work, we need to say, okay, now it's on the book. We know it's based on the WTO model. So we need to know exactly what this WTO is, what it's part of the law of the AfCFTA. And you see that if you look at the preamble of the AfCFTA, it says determined to strengthen our economic relationship and build upon our respective rights and obligation under the constructive act of the African Union of 2000, the Abuja Treaty, and where applicable, the Marrakesh Agreement establishing the World Trade Organization of 1994. AfCFTA tells us right there. So therefore, in our curriculum, before we all become lawyers, we were all students. So I want to go back to my students when I'm teaching them and really in Africa, really teach them African Union law and tell them about the African Union institutions, the regional and community court system, for them to know the compliance under the AfCFTA, international compliance, and make no mistake, what Mohammed was talking about with regards to bribery or corruption. So you need to also incorporate the Foreign Corrupt Practice Act and the UK Bribery Act in that teaching as well, because we know that there is something under international law that is called universal jurisdiction. So it doesn't matter where you are as an American company. If you come to Africa, you commit a crime with bribery, they're going to reach out, they're going to get you. So all these things, we need to know how it works in the context of the AfCFTA. So you need to know the GATT and all these MFN obligation, those modification, like we've gone over. So briefly, I have to say, African Union law is part of public international law, and it needs to be recognized and it needs to be taught. And when we are teaching from the law school, now when we have our new lawyers coming out, they won't be afraid of taking those cases. And we will talk less about this diversity 20 years from now because it will already be diverse. I'll stop there.
I think that's a great place to stop. Thank you to my panelists. Thank you very much. So I don't know if we kept to the exact, did you want to? No, I don't think we kept to the exact time, but thank you to all of you for all the preparation and the presentation on this topic. It was a really engaging discussion for me, and I'm sure for those listening in as well. Thank you.
Thank you.
We should take a photo of
Yes, yes, we should. Let's do that.
Yeah.
Yes.
That's fine.
Should we go down from here?
Yeah.
Who's the?
Oh.
Thank you very much.
David?
Again,
Have you heard from David?
Yes, he's online.
Okay.
as per usual, if you have your mobile phones on, they should be on silence or you can switch them off completely. We are going to have our last panel before lunch. And I hope you will bear with us in terms of the timing. We started late this morning, so that is having a knock-on effect. But we will try as much as we can to make things interactive at certain points. So it may be that at the end of the day, just before we go, we'll have some time for general questions and answers. While the panels, they have the discretion to grant time for question and answer as they see fit as we go along. So this is the sixth panel now, and it is going to be moderated by Matilda Udon Donko, Rainford Chambers, Mr. DLA Pipers Africa, Ghana, and Sophia Vale. Yes, okay, good. And the other members of the panel include Tarek Badawi, Yasmin Lalu, Bilshan Nusimulu, David Otenelta. As I say, my pronunciations of the name could be really bad. So when it is your time to speak, please feel free to say your names again and a bit about yourself, so that I could be corrected in that way. Without taking further time, I now invite the moderator to take over.
Thank you. Dear colleagues, we shall now start panel 6, which aims at discussing effective enforceability of arbitration awards in Africa. One may sustain that enforceability is indeed the core of arbitration. For an award is of no relevance if it is not able to produce the effects it aims to. In order to shed some light on how to overcome challenges raised by enforceability of arbitration awards in Africa, and I will do better than you in pronunciation, Tarek Badawi, Yasmin Lahlu, Bilsham Nurzimulu, and David Unterholter. David is going to be joining us from Zoom because he's in London. So they will share their experience with us. Notwithstanding the fact that you may find their respective bios in the AfAA app, please do allow me just to briefly introduce you to our speakers. So Tarek is a partner at Mason Partners in Egypt and in the United Emirates. He specializes in dispute resolution and represents clients in trade, competition, commercial, media, investment disputes before international arbitral tribunals, courts, and administrative authorities. Bilsham is a barrister at Horizon Legal in Mauritius. He specializes in commercial and corporate disputes with particular focus on recovery matters. He's a ranked lawyer by Chambers and Partners and Legal 500 for dispute resolution. And he was also shortlisted last year for the African Arbitration Awards in the category of Young Arbitration Practitioner of the Year. So congratulations. David, which will be joining us via Zoom, as I previously mentioned, I'm sorry. He enjoyed a leading practice as a barrister in South Africa and London. So from 2006 till 2013, he served as a member of the appellate body of the WTO and was the chair of the appellate body in 2010-2011. In 2018, he was appointed to the High Court as a judge and has since held appointments on the Competition Appeal Court, the Constitutional Court, and is currently an acting judge of the Supreme Court of Appeal here in South Africa. He has done extensive international arbitration work under the auspices of ICSID, PCA, and ICC, among others. He is also a law professor in various universities and also here at University of Cape Town. Yasmin, she's a partner at International Disputes Boutique Chaffetz Lindsay in New York. She's a polyglot. She's fluent in English, French, Italian, and Portuguese. So Yasmin, she has over 20 years of experience in international arbitration and litigation. She was initially trained in Paris and admitted in New York. So she's really experienced in civil and common law systems. She represents clients in various arbitration proceedings, and also acts as arbitrator. As for me, my name is Sophia Val. I am a professor at the Faculty of Law of Agostinho Neto University in Angola. And I also act as arbitrator, and I have been recently appointed to the arbitrators panel of ICSID by the Republic of Angola. Here by my side, I have Matilda Idon Donker. She's a lawyer with 14 years of experience in corporate commercial law, in dispute resolution, in natural resources law, tax and employment in Ghana. So together, we will try to keep your attention during this session and preventing you from falling asleep until lunchtime arises. Let's do it, Matilda.
Yes,
The floor is yours.
thank you. Usually when it comes to enforcement of arbitral awards, we only, get to that stage after obtaining the award. But our panel today wants you to think the end from the beginning. When you are negotiating arbitral awards, you should have on your mind the fact that if the award is not going to be enforceable at the end of the day, it is a worthless piece of paper. So my first question will be to David. David, what do you think that parties must think about during the contract formation stage to ensure that the arbitral awards that they obtain at the end of the day will be enforceable?
Excuse me, I have a bit of a cold, but yes, thank you very much for the opportunity to participate in this panel. I agree with you entirely. One needs to think at the beginning where you might end up if you win the arbitration and seek enforcement. So in framing the agreement, there are a number of key things to bear in mind for the purposes of ultimately securing enforcement. The first, I suppose, is quite obviously that you must frame this in a written agreement, and it must be perfectly clear that you have done so for the purposes of ultimate enforcement. More importantly, or as importantly, is to define precisely what is being referred to arbitration. This matter is possibly something that is not given sufficient attention to, because it matters a great deal what precisely is within the ambit of arbitral resolution, and careful thought must be given to it, lest an arbitration should stray beyond the bounds of what is specifically referred. The third proposition is what is the applicable law of the arbitration agreement, and questions of validity of the agreement under that law, and the law which is likely to be applied for the purposes of enforcement must be carefully thought through. There is then importance that attaches to how the tribunal is to be constituted, and the procedures that are to be followed so that there can be a proper constitution of the tribunal and notice of its appointment can take place. And then the issue must be one which provides quite clearly for how the award is to be rendered and how that award relates to the dispute that is referred. All of these are elements very well known, but sometimes because they're so well known, they aren't given very careful attention to, because a boilerplate agreement of some sort is used, which may be inapposite for the purposes of the particular arbitration that is sought to be engaged. And I would say, therefore, that the best approach to framing the agreement is to think carefully about what are the grounds ultimately on which enforcement may be challenged, and to make sure that the agreement, as best one can, frames matters clearly and with a view to ensuring that enforcement is possible and that possible grounds of challenge are minimized as a risk to the ultimate success of the arbitration process.
Thank you so much. Tarek, you just heard David. Do you have any additions to what he's just said?
There are important issues that people must consider in the context of drafting arbitration agreements. The first point I always emphasize, and I always tell clients, please engage local counsel before signing an arbitration agreement, and not after the dispute starts. That's a very common mistake. I mean, fortunately, I've gotten a lot of work as a result of that mistake, but this is something that should be avoided. We need to focus more on dispute avoidance rather than look at the resolution aspect of a dispute. So, you know, there are several examples that I could speak to from Egyptian law where, or in the context of Egypt in particular, where, you know, some of these mistakes arose as a result of not consulting local counsel at the right time. So, you know, the first one, and Aisha yesterday mentioned that Egypt has a vibrant arbitration scene with a particular emphasis on construction arbitration. Well, you know, under Egyptian law, any agreement that relates to an immovable has to be subject to Egyptian law.
Right.
So oftentimes you would have parties subjecting a dispute to the laws of another jurisdiction involving an immovable or the construction of an immovable asset located in Egypt. If you get an award, it will not be enforced in Egypt for violation of public policy. Another example relates, very similar example, and the Court of Cassation has recently issued a decision on that, relates to transfer of technology agreements. Now, this is very common in the pharma industry and you know, the tech industry in general, where you have a foreign-based entity that contracts with an Egyptian entity. The contract or the essence of it is about the transfer of know-how and technology. Well, again, under Egyptian law, it has to be subject to Egyptian law.
Right.
Otherwise, and that, you know, there was a reason for that back in the 90s when the commercial code was enacted to provide additional protections to local industries. So very often we see agreements subject to Swiss law in particular. And, you know, going forward, especially in light of the recent decisions of the Supreme Court, it has become more apparent than not that it will most likely not be enforced in Egypt. Another one which was subject to extensive debate relates to administrative contracts. So government contracts in particular. There's a very clear definition of what an administrative contract is in Egyptian law. Not all government contracts qualify as administrative contracts, but effectively an administrative contract under Egyptian law is a contract that must satisfy three requirements. It has to be entered into by a government entity. So that applies to all public works contracts, for example. The contract has to relate to the management of a public utility. So I'm thinking electricity grids, for example. And it must contain exorbitant clauses. And that means the government entity has the right, for example, because there are multiple examples, to amend the terms of the contract in the public interest. So there's a qualifier here. Or to terminate it for the public interest, of course, against paying adequate compensation. Now, under Egyptian law, and that's a norm of public policy that was confirmed by the Supreme Court in 2015, an administrative contract that contains an arbitration clause, the arbitration clause itself has to be approved by the relevant minister.
Wow.
Now, the approval can be explicit or implied. It's not very easy to prove implied consent in those situations, but imagine the stakes of entering into a multi-billion-dollar administrative contract that contains an arbitration clause. The minister does not approve it. The party wins the award, will not be in a position to enforce it in Egypt because it will be deemed to be against public policy. And the court of competent jurisdiction in that case will be the administrative court of Egypt. So these are three examples. There are other examples relating to interest, caps on interest. I can speak for hours on that, but I'm conscious of the time. The two other things I would advise local counsel in that case would be avoid pathological clauses. It's very common in arbitration clauses and typically drafted by non-practitioners, non-specialists, I mean, to contain 4 layers of mediation and having the second person in command in each company to engage in negotiations 30 days after the breach, etc. You know where I'm going with that. In 90% of these clauses, the awards get annulled. Make it simple, state what you want, state the process, avoid several levels of dispute.
Escalation.
escalation, that's the right word, and just make it simple.
Right, thank you so much. We want our session to be as interactive as possible, so we'll be calling on members of participants to, be part of our panel. So I have a question for you. In formulating your claims, do you have enforcement on your mind? Is the fact that you must formulate your claims such that when an arbitral award is rendered in your favor, it will be enforceable. Is that a consideration that participants here, always have on their minds when they are formulating? Can I call on Mr. Ostrov? I put you on notice.
Thank you. You put me on notice, but still caught me by surprise. In formulating claims, it's not top of the mind. Will this be enforceable? Usually we're much more thinking about, the law and the facts and what the claim is that we need. But it does happen that we think, is this a claim that an arbitration tribunal has the power to grant? Sometimes when we're thinking declaratory relief or injunctive relief, we have to think in the place of enforcement, is this something that will be enforceable? And then making sure that it's as clear as possible, because we don't want to make the task difficult for the arbitrators at the end of the day and run the risk that there's an ultra petita or an infra petita problem and create difficulties. So I think clarity and making sure that the claim is going to be within the scope of authority of an arbitration tribunal. Sure.
Thank you so much. Yasmin, I'm back to you. Do you think that some expertise around enforcement is required so that, you get your arbitral awards, the lawyers and other practitioners, the arbitrators, they finish their work. Do you now think that there should be one should have some expertise in enforcement in order to enforce an arbitral award?
Yes, that's a very good question. I think the answer is absolutely yes. And it is not only a specific know-how, but it has to be a domestic know-how. This is very jurisdiction specific, because this is where the state apparatus comes in and offers its support to enforce an award. We are no longer in the world of arbitration. We are in the world of civil procedure. Of course, the New York Convention came in and offered some level of uniformity and basically offers the baseline, imposing a duty on states to recognize and enforce an award. But that is only the beginning, because then how you get there will depend on the domestic rules. There is some level of uniformity in Africa. For example, the AfAA has the 1998 Act on Uniform Rules of Execution. So these will govern, enforce execution measures in those 17 member states of AfAA. But you will need very specific know-how, because you will have, for example, in the United States, you have a 3-year statute of limitation if you want to enforce an award. You need to be familiar with that. Even in the New York Convention, you have differences, because the New York Convention refers to an agreement in writing and an arbitration agreement in writing. This has not been interpreted the same way in all jurisdictions. Some jurisdictions actually require that the arbitration agreement be in writing. So that raises a true issue when you're dealing with non-signatories, because by definition, a non-signatory, we will not have signed a written arbitration agreement. So how do we deal with that? In the US, recently a party tried to resist an award as a non-signatory, saying, the New York Convention requires an agreement in writing. I haven't signed this agreement. I am not bound. But the New York Convention says, the Supreme Court said, no, the New York Convention offers like a sort of a baseline, a threshold, and then you can improve on that. And this is exactly what the US system is. And there is another thing that I think is important when you're dealing with enforcement of awards, especially in developing countries, and when you have developing countries, meaning developing the law of arbitration is that you need to enforce responsibly. Like
Right.
you drink responsibly, you enforce responsibly. When you know that eyes are on your jurisdiction in developing a consistent jurisprudence on enforcing award, recognizing awards, you should not be making frivolous arguments because you think that will play to your client's advantage. I think you need to serve your client's interest, but you should not be making frivolous arguments because you are currently building the law of arbitration of enforcement of awards of tomorrow. So in that way, you should not be pushing judges to go to the least common denominator about public policy, etc. But I think we can discuss that
Okay.
a little bit.
Belgian, you practice in Mauritius. In Mauritius, are foreign arbitral awards generally recognized? What are the processes that one has to go through to enforce an arbitral award in Mauritius?
Thank you, Matilda. The enforcement of foreign awards in Mauritius is, as many would know, governed by the New York Convention. The particularity of the Mauritian jurisdiction is that the New York Convention applies not only to the enforcement of foreign awards, but also to the enforcement of awards issued in international arbitrations seated in Mauritius. So that helps to build the case law of the Supreme Court to a great extent, because the cases that the Supreme Court deals with under the New York Convention applies both to foreign awards and awards in arbitration seated in Mauritius. There's a good body of case law that has been developed by the court over the last 2 decades, and we have a direct an automatic right of appeal to the Privy Council, and most decisions of the Supreme Court under the New York Convention have been upheld by the Privy Council, except for one decision that has been very widely reported and commented in the international arbitration community, and that's the case of Betamax Limited and the State Trading Corporation. That case dealt with the powers and the jurisdiction of the supervisory court to delve into issues of legality that were decided by the arbitral tribunal. I say the supervisory court because Betamax was an arbitration seated in Mauritius. There were 2 applications simultaneously being decided by the Mauritian court, and that was an enforcement application and a setting aside of the award application. Both applications were determined in a single judgment. And the issue there in the arbitration was whether the underlying contract was in breach of the public procurement laws of Mauritius, which the arbitrator found was not. The court delved into the issue and found that there was legality, and the legality amounted to a breach of public policy. I know that we're going into public policy a bit later in this panel, but on appeal to the Privy Council analyzed the decision of the Supreme Court and other jurisdictions that have considered public policy consideration, and held that where there's no illegality on the face of the award, that is where the arbitrator has decided that there was no illegality, the court was not in a position to, was not entitled to delve into the issue and determine whether there was illegality, which would be in breach of public policy. So that was the only decision that was overturned by the Privy Council on appeal. Coming to your question about the process and procedure, I think Mauritius has a very user-friendly procedure to enforcement since the new rules came in around 2013. There's an ex parte application that is made to the Chief Justice for enforcement of an award under the New York Convention. That application is based on witness statement. It doesn't even need to be an affidavit, so to do away with the legalization and apostille process. And the Chief Justice jurisdiction is only to verify compliance with Article 4 of the New York Convention. So whether the documents required under Article 4 have been produced in the application, and if upon verification of that compliance, the Chief Justice automatically grants a provisional order, which is generally given within a matter of 1 or 2 days. And the respondent then, upon being served with the provisional order, has the ability to then apply within a strict timeline to the court for setting aside the provisional order. And as I said, there's then after determination of the setting aside application, there's an automatic right of appeal to the Privy Council.
Right. Thank you so much. I think enforcement across jurisdictions is very important if African states would be attractive as a venue for arbitrations. Now, OHADA, we don't have anyone on our panel who can speak to enforcement proceedings under OHADA law. So my question is back to you. How is the enforcement process under OHADA implemented? Can anyone answer? No one? Oh, Sylvie? Okay, help us, please. I think one attractive thing about, OHADA is the fact that, you get an award in one OHADA state and you can enforce it in other OHADA states. Am I correct?
Thank you, Matilda. I think it's important, first of all, to mention that we have a dual arbitration system within OHADA that you need to really put apart. We have the what we call the common arbitration,
Right.
which is based on the OHADA Uniform Act on Arbitration,
Okay.
which contains the general rules on arbitration. And we have the specific system based on the CCGA, which is the Common Court of Justice and Arbitration of OHADA, is the common court of the Supreme Court of all the OHADA states, but is also has a specific OHADA arbitration. So this is the first thing you have to really consider when you are dealing with OHADA arbitration. So within this OHADA system, based on the OHADA Arbitration Act, which have been reformed in 2017, you have now a specific enforcement procedure, which said that you can have the executory within 15 days.
Right.
You present your request before the president of one of the OHADA state courts where you need to enforce your award, and you have this executory. But this is a national. It remains a national system. That's why I started by stating the difference. And now you have this common justice and arbitration rule system within which you can also ask, because it's a very specific system. So you have to really think when you are dealing with OHADA that you can have an arbitration clause within CCGA, and you can have an arbitration, a more general arbitration clause where you choose whether ad hoc arbitration or whether you can choose an arbitration rule from the private center. For instance, what we had yesterday with Lina Law, the CEMAC, which is the arbitration, one of the leading arbitration centers in Cameroon. So when you choose the CCGA rules, there you have a specific enforcement procedure where you have this executory within also 15 days. And this is the one who is enforceable, who make the award enforceable within the 17th arbitration state, OHADA member states. So is a big difference you have within OHADA. This executory, which we call the regional executory within OHADA, which make the award enforceable within the OHADA states. But out of the OHADA state, you will have to cope with the enforcement as it states under the New York Convention. For instance, there have been many OHADA arbitration awards which have been enforced out of OHADA based on the national rules of the country where the enforcement is sick. So that is the two enforcement system we have within OHADA.
Thank you. Thank you very much. Tarek, you've heard about enforcement and the New York Convention. We've heard about that under OHADA. Now, can you tell us how different enforcement proceedings under the Riyadh Convention is?
Well, the Riyadh Convention it's a regional convention comprising the majority of Arab states, and it is really an agreement on judicial cooperation. So it's not arbitration specific.
Right.
But it does provide, it does cover arbitration, and it has very interesting rules that are different from the rules that apply, for example, in the context of enforcing awards under the New York Convention. My experience with the Riyadh Convention has been bittersweet in a funny way, and it's a bit of an anecdote that needs to be told. So one of the interesting perks of the Riyadh Convention is that you can notify a party through courts. Typically notice, at least in Egypt, is done, if it's of a cross-border nature, it's done through the prosecution. You approach the prosecution, notify the award or serve the award onto the prosecution, that then sends it to the Ministry of Foreign Affairs, that then sends it to the embassy in the foreign jurisdiction. And it's a process that takes 3 months. So it's a very lengthy process. And when you need to enforce an award and you want to notify the party of the deposit, it takes a very long time. So of course, we found that little loophole in the Riyadh Convention. We went to the judge, and then we faced our first hurdle is that the agency in the country that we wanted to notify, so we needed to notify an agency in a foreign jurisdiction. Postal services to that jurisdiction were suspended because there was political instability in that country. So we managed, and first we were very proud, thought that we outsmarted the system. We managed to obtain the judge's approval to serve that other jurisdiction by means of courier, which is unheard of in Egypt. It was like the first achievement, and we were extremely proud of it. We mailed the submission with the court's approval, made it to another jurisdiction, but during that process, flights to that country were suspended.
No.
So we spent about 2 months tracking the parcel that was being transferred by truck across the Arabian desert for 2 months. So we ended up spending the same 3 months that we wanted to avoid in the process. By the time the parcel made its way to that jurisdiction, there was a new government, and we had 2 competing governments in that state. Some of those, one of them was recognized by the Egyptian government, the other was not. It was in power in that part of the jurisdiction that we wanted to serve. And then to add insult to injury, that state withdrew from the Riyadh Convention in the process. So it's sweet because we did manage to get the court's approval to serve by means of courier. That's definitely a precedent that is worthy of mention. But it's also bitter because we wasted about 3 or 6 months actually, and we found alternative means to deal with the process. So my experience with Riyadh hasn't been the best. However, the tools are there. They do allow for expedited enforcement. Now, the flip side of the coin with the Riyadh Convention, and that's the issue that has been the subject of a lot of debate and academic discussions, is that it has an onerous enforcement process. So we need to obtain the exequatur in 2 jurisdictions. We needed to get it at the seat, and then we need to get it at the jurisdiction where we want to enforce and provide evidence of having obtained the exequatur at the seat. So that's an onerous process that is lengthy. In some jurisdictions, it can take several months, maybe even years. So I feel that the convention could defeat the purpose of its enactment in a way. So that's why I call it's more of a convention on judicial cooperation. streamlined service, but not necessarily the best tool to follow when you want to implement an award. Now, in practice, this can raise another legal question as far as Egypt is concerned, maybe not the other jurisdictions, is that the Riyadh Convention was ratified in Egypt after the New York Convention. So when you're faced in the jurisdiction, in the constitutional hierarchy, well, not hierarchy, but in the constitutional structure of Egyptian law, it is the more recent law. So does it override New York when we're dealing with a jurisdiction that is party to both conventions? That's a question that will have to be addressed. The Court of Cassation has fortunately ruled, not on this specific question in particular, but ruled that when facing enforcement, the courts should apply the less onerous procedure. So that in a way is a suggestion that if one day we're faced with that choice, then more likely than not, the New York Convention will apply. However, there is an additional layer that we have to deal with, is that there's a new trend within the Court of Appeal, which is really the court responsible for enforcement matters and annulment claims, etc. Recent judgments showed that there's probably a carve-out on what the Court of Cassation said. So in a recent judgment by the Court of Appeal, the court said that if an award is subject to foreign law, obtained overseas, and is to be enforced in Egypt, unless the parties specifically agreed to apply the Egyptian Arbitration Act to enforcement, then the procedures found in the Civil Procedures Code will apply. Now, this is a problem in a way for enforcement, because under the New York Convention and the Arbitration Act, the enforcement process is done on an ex parte basis.
Right.
So it's faster. I'm not saying it's very fast, but it's certainly faster. The procedure under the Code of Civil Procedures treats it in a way, or treats enforcement in the same way you're dealing with the enforcement of a foreign judgment. So that means you have to start a new claim, not on the merits, but you have to notify the other party. Again, that part, just to notify the party takes, I told you, 3 months.
No.
And the party will come to court, obviously will employ every tool in its possession to delay enforcement. So we are looking at a minimum of 2 to 3 years to be able to get a judgment to enforce an award that was issued overseas. And the party's only mistake is that they haven't explicitly stated that the Egyptian Arbitration Act will apply. Again, this is not an issue that was addressed by the Court of Cassation. I'm hoping that soon this issue will make its way to the court and it will settle the matter once and for all. Again, hopefully sticking to the same line of decisions by the Court of Cassation, promoting the less onerous enforcement process.
Thank you. Yasmin, enforcement under exit convention. Can you speak to that? How different is it? How more efficient is that?
The exit convention is very unique because it's its own self-contained mechanism within the exit system. You have an award, and if you want to challenge the award, then the exit will appoint an ad hoc committee that will evaluate the validity of the award, and they will either confirm it, vacate it in part or in whole, and it can go to another tribunal. Once the ad hoc committee has upheld an award, or it hasn't been challenged, then you go to Article 54 of the exit convention, which basically says that the member state have to recognize an exit award as if it were a judgment of their own courts. What it means here is that unlike the New York Convention system, courts of the member state of the exit convention can only basically verify the existence of an award, verify the existence of an arbitration agreement, because that is usually the way that a court will have subject matter jurisdiction over a sovereign, because we're talking about enforcing an award against a sovereign. So, for example, in the United States, to have jurisdiction over a sovereign, you need to have a waiver, explicit or implied waiver at service. If you have served the sovereign and you have this waiver, you have jurisdiction over the sovereign. And under US law, like under, I think, South Africa law, under customary law, when a state has agreed to arbitration, this is usually considered as a waiver to jurisdictional immunity. So once the court has verified that, basically it will rubber stamp and will affirm all the monetary aspect of an award. Other aspects of an award, they will not necessarily enforce. They have discretion to do so. But when it comes to the monetary aspect, they will enforce. The little wrinkle right now is, and we were talking yesterday about the pushback against investor-state arbitration. Well, in the European Union, you heard about just an hour ago, they were talking about Comstoy, AfAA, and now basically saying that member states cannot agree to arbitration. They did not have the authority to arbitration within the system. And now, so Spain has come to a court in the US saying, I did not agree to arbitration, hence you do not have subject matter jurisdiction over me and you cannot enforce this ICSID award. This is going to be interesting because one district court said, I agree. Another district court said, no, there is formally, there was a written arbitration agreement. Whether or not you're bound by it is a substantive issue that was addressed by the tribunal. I don't care. This is all going to the Court of Appeal and it will be decided hopefully this year or next year. And this is going to be a big deal. Naturally, as you know, you will have this very favorable exit mechanism provided you have an exit award, which requires that you have an investment dispute and be resolved under exit. If you have even a bilateral investment treaty arbitration under UNCITRAL, you cannot look to the exit mechanism, to the exit convention to enforce your award. You will have to go to the New York Convention. And one last point to Tariq's story is that if a member state is also a member of the Hague Convention on Service, you have to go through the process of serving the state according to that convention. And here we're talking about usually 9 months before you are able to serve a state. It's interesting because we were representing Egypt, and the award creditor was able to get permission from the federal court to FedEx the award on Egypt. Egypt never found out because I think some Mohammed signed the DHL receipt, and just left the thing there, the petition there. No one at the Ministry of Justice who was responsible for handling that had heard about it. So it's only once we saw that, because we had a docket alert that the creditor had filed an affidavit of service saying, oh, there's a problem. So we rushed to the court and we got an extension to be able to respond. But I think that we are able to do that because I think Egypt is not a member of the convention, and that's why they were able to go to court and get permission to serve via courier. But if not, you're talking about 9 months of efforts.
Yes. David.
Yes.
Okay. So you are a judge. Can you share some practical advice to persons seeking to enforce arbitral awards in South Africa?
Yes, I wonder if I may just go back for one moment to pick up and just reinforce a couple of things that Yasmin has said about ICSID and the New York Convention, because I think there's an important contrast between the two. And I'll then come back to the question of enforcement in South Africa. So, as I think is well understood, ICSID awards are final, binding, and exclusive and constitute res judicata. And there is consequently, when enforcement is sought in the court of a state party to the convention, the question is really one of authenticity. It is not one that permits of the kind of review of an ICSID award that might arise under the grounds that are relevant for enforcement under the New York Convention. And that's one of the key differentiating factors between the ICSID Convention and the New York Convention. There is, though, I think, a wrinkle to this, which is really one that arises under Article 55 of the ICSID Convention in respect of pecuniary awards and the ability to effect attachments, where one is dependent upon the national laws for enforcement through execution process. And there is not a carve-out in respect of state immunity, and perhaps we'll come to that in due course. But just to see that under the ICSID Convention, the kind of review that might happen in respect of enforcement mechanisms under the New York Convention is really something that is reserved for annulment proceedings within the ICSID Convention itself under Article 52. And so there is quite a distinctive set of regimes that apply, whether your arbitration is one that comes about through ICSID or whether you are dealing with it under the framework of the New York Convention. Let me then come to your question around enforcement in South Africa. South Africa has a sort of bifurcated system of laws in respect of arbitration, where domestic arbitrations are regulated under the Arbitration Act, whereas foreign awards are regulated under the International Arbitration Act, which in effect, in express terms, simply adopts the New York Convention. So it is a friendly jurisdiction for the purposes of enforcement, and where I think those familiar with enforcement under the New York Convention will find that the courts in South Africa will apply the New York Convention in a very predictable way that is well understood in other jurisdictions. And that has been done very expressly in order to encourage the use of international arbitration and South Africa as a seat for such arbitration. And that has been an important innovation in our law, which came about through the passage into law of the International Arbitration Act. That is in brief its position in South Africa.
Thank you. Bill Shedden, the last question to the panel, then we'll open it up for discussion. Do you think that the public policy exception to the enforcement of arbitral awards is uniformly understood or applied on the continent?
I think a realistic view is that the public policy exception is not uniformly applied across various jurisdictions in the world, and it's not just an African problem. And I referred to the case of Betamax earlier, and I think that's a good illustration of the extent to which in some of the major arbitration jurisdictions, that a public policy exception is not uniformly understood, and the scope of it is not applied uniformly. The Supreme Court of Mauritius in the Betamax judgment relied on observations made by two foreign courts. One is the UK High Court in a case called Soleimani and Soleimani, and also to commentary made in a Singapore Court of Appeal case of AJU and AJT. In the Soleimani and Soleimani case, the High Court found that the arbitrator in the award dealt with the issue of legality and found that the underlying contract was illegal, but went ahead to enforce that contract. And the High Court found that the court was entitled to look into whether the illegality amounted to a breach of public policy. But the court went further to observe that even if the arbitrator had not dealt with the illegality question, the court was entitled, on prima facie evidence brought by the award debtor, to look into the legality and whether it was in breach of public policy. That was not, of course, the reasoning that led to the determination in the case. It was an obiter comment that was not followed in other decisions of the UK Court of Appeal. But that was not an element that was considered in the Mauritian judgment of Betamax, the fact that Soleimani was not followed by the Court of Appeal in other cases. And the Mauritian court also looked at the decision of the Singapore Court of Appeal in the case of AJU and AJT. And again, it was not the reasoning. In the Court of Appeal of Singapore, they basically echoed the views, the obiter comment in the Soleimani case by the UK High Court, but it wasn't the reasoning that led to the determination of the case. On appeal to the Privy Council in the Betamax case, the Privy Council criticized the observations made by these two courts, first because they were not necessary, because they did not lead to the determination of the issue in the case, but also adopted a narrow approach to the scope of the public policy exception. And the Privy Council's decision was that if there's no illegality on the face of the award, then the court cannot go into the merits and look at whether the contract was unlawful or in breach of the public procurement laws. But that case, apart from the decision of the Privy Council, the case illustrates that even in jurisdictions such as England and Singapore, there seemed to have at some point been some inconsistency or incoherence in how the different courts adopt the approach to public policy exception. And there was a recent case decided by the Singapore High Court either this year or last year, in which reference was made to the Betamax case, but the Singapore High Court considered first that there was no question of legality, but even if there were, it would leave it to the Court of Appeal to decide whether to follow Betamax, because the High Court is bound by the Singapore Court of Appeal judgment and not by the Privy Council judgment. So I think it's a space to watch in terms of how the citation to the Privy Council case in Betamax is going to be followed in other jurisdictions. But even if we cross the channel from the Privy Council and look at the French courts, the French courts adopt the opposite approach, which is the maximalist approach. They would adopt a de novo review of the legality question. So even in those sophisticated arbitration jurisdictions, there doesn't seem to be some sort of convergence in views on the right approach to take and the extent and the scope of the public policy exception. Coming to your question about African countries, I think first my experience is limited very much to the Mauritian jurisdiction, but the problem I see with the public policy exception in African countries is first that there is very limited reporting of the cases that have decided the public policy exception and its application. I found a few of them that have been commented in, by law firms and practitioners. Doesn't necessarily go into the depth that is required for us to ascertain whether it's in accordance with the minimalist approach adopted by the Privy Council or the maximalist approach adopted by the French courts and perhaps other courts. I think the South African, there's a recent South African judgment that seems to be more in line with the Betamax judgment of the Privy Council. Tarek mentioned in Egypt, the interest rate would be a matter of public policy. I think there was an award rendered in which the interest rate was in excess of the maximum rate allowed by the Egyptian law, and that was seen to be in breach of public policy. There's not much that's been reported for us to see what's the rationale, as in what is the underlying rationale to see whether that's in whether that's within the narrow or the larger approach to public policy. I think that's a matter on which will be interesting for practitioners from different jurisdictions to comment on the decisions that are being delivered by the local courts, for there to be some sort of awareness and knowledge of how different courts across Africa are determining the public policy exception.
Thank you so much. Thanks to the panel. Julius, can we take questions for 10 minutes?
Yes.
Okay, thank you. Some hands are already up.
So if anybody has a question for the speakers, please do raise your hand. I'm seeing a hand over there.
Thank you so much. I'm Eme Mbarushimana from Rwanda. I thank the panel for the discussion and the way this topic is made clear. We can understand the particularities of execution of awards. One question. I like the introduction, which brings us as parties or as council to parties to have the execution in mind when drafting the agreement. But I have a concern about the diversity that we have. You can have an arbitration, a contract in which you have parties from different legal systems. Clearly how to deal when we have parties from one client or the buyer or the seller, they are coming one from the common law system, the other from the civil law system, how to go up to the execution while dealing already with this kind of diversity. We have developed countries versus undeveloped countries.
I'm sorry.
Islamic countries.
Sorry, I would just ask you to be a little bit more concise with your question, because we are all hungry and we want to go for lunch.
Thank you. The other element is about pro-arbitration countries and non-pro-arbitration countries, how to deal with all those disparities. Thank you.
Yasmin, would you deal it with the civil and common law?
Divide?
Yes.
I think when it comes to enforcement, you will not necessarily be looking at this sort of distinction. I think the distinction is going to be on certain conception of arbitration law. One particular difference I have in mind, because most of the states I'm talking are usually New York Convention, parties to the New York Convention, etc., and then they all have their own system when it comes to enforcement. Some issues that you have to bear in mind is, for example, something that I was referring to earlier is, for example, non-signatories. When you're trying to involve a party who did not sign the arbitration agreement in the arbitration, you have to be very careful on what theory you will build your non-signatory case. Because as you know, in France, for example, there is the group of companies doctrine that was adopted in the early 80s by a very prestigious tribunal presided by Dr. Goldman. And that tribunal found that under principles of international law, you can raise the group of companies doctrine, which allows a parent company to invoke an arbitration agreement signed by its affiliate and to be a party to the arbitration agreement. English courts say there is no such thing as the group of companies doctrine, and we will not enforce an award that has found a third party liable on that theory. So this is the sort of differences, but you will have all the theories to get you a non-signatory under English law. And I think you'll have the Dala decision in this situation. And it happens to be a divide between the French and the English, but I think it's more of a historical, the Waterloo opposition between these two countries more than really a civil law, common law divide.
Thank you, Yasmin. I'm sorry, over there, because it was your hand that I saw first after.
Okay, good day. My name is Esosa. I'm from Nigeria. My question does not really stem from the presentation today, although it's an enforcement issue, so perhaps I should give a bit of a background. I was recently involved in an arbitration in which my firm represented the respondents. At the conclusion of the reference, the panel determined that the respondent was the winner, the winning party, for purpose of refunding the cost of arbitration. Now, there were 22 reliefs claimed by the claimants in the arbitration. And then the panel distilled 14 issues for determination. And out of those 22 reliefs, 21 were rejected. And out of the 14 issues, 10 were resolved against the claimants. And on the basis of that, the panel held that the respondent was the winner. Now, the claimant has filed a suit to set aside the arbitral award of costs, claiming that it was the winning party. Now, my question is this: are there considerations other than the obvious, or considerations that are extraneous from the obvious, that the panel should take into consideration in determining who the winning party is and who the losing party is? Because I'm still finding it hard to wrap my head around the logic. If you claimed 22 reliefs and only one was granted in your favor, then out of 14 issues, 10 were resolved against you. By what logic can you say you are the winning party?
Right.
So I'm wondering, are there other considerations other than the obvious in determining who the winning party or the losing party is?
Thank you.
I think your question does not really relate to enforcement, but if one of the panels.
You said considerations other than what?
So that.
Other than the obvious, like
Other
if,
than?
if in your award you determine,
Other
okay, based on the
considerations
reliefs claimed
determine-
and the quantum of the relief granted or rejected, based on the issues raised, the quantum, based on the quantum of the issues decided in favor of one party against the other party.
Is this in the context of determination of costs? Who bears the costs of the
Yes.
arbitration?
I think one important consideration is the relative size between your claim and what you got. I think to the extent that you made a $10 billion claim and you actually were only entitled to $1 million, you may not be considered as the prevailing party, even though you won in the end of the day. One important consideration is to the extent you delayed the arbitration process. It's basically your conduct in the arbitration is highly relevant. Because to which extent you have caused the other side to incur fees that they should not have, and same for you, because to the extent that you have delayed the arbitration, you have incurred costs that you should not recover either. These are really
These
main
are
issues.
two main issues, and it is a process that is really subject to the discretion of the tribunal. I mean, you have to look at the institutional rules, for example, if it's governed by, if it's an institutional arbitration, and many institutional rules states that, the losing party will pay the costs unless the tribunal thinks otherwise. So there's always that exception. And that exception really allows the tribunal to do what Yasmin was saying. I mean, we look at the conduct of the parties, you look at the relative gain that a party achieved in light of what that party claimed. There are multiple issues that you consider. And in the end, it is really a discretionary matter. And whether or not that could be subject to annulment, you have to look at the applicable law in that case. But arbitrators generally enjoy wide discretion in this specific matter.
Now, if that discretion has been exercised by the panel in determining that one party is the winning party and the other party is the losing party, can the party who lost question the basis of arriving at that determination by the panel?
If you allow me just to add something, well, at least it's from my experience in Angola, okay? And there is indeed this with discretion that Derek talked about. So it's quite normal for me when I act as an arbitrator, even if you have a complete winning party and a complete losing party, okay, in what the claims are concerned, it's common that they both share the costs of arbitration. It's not mandatory that the losing party needs to support all costs arising therewith. So
I would just add.
it depends on the particular case, but we can give you a free consultancy over lunch. I have no problem on that. I can share my experience with you, fact by fact. But there was here another colleague that wanted to raise.
Last question. Last.
Sorry, there is this colleague over here.
Yeah, Sophia, I'll be quite brief, conscious of the special moments before lunch. Two comments. First, let me appreciate the panels. I think I found this very rich. My first two comments, my name? Okay. I am Dr. Wayne. I am part of the CIAB delegation from the Kenya branch. So two quick comments on the formulation of claims. I think the pattern is very different when it comes to third-party funding, where the financier has a greater stake. So they will not only look at the merits of the claim, and they'll pay a lot of attention to enforcement issues. So I think that's a very interesting discourse there. Second, I think the subject tends to look at OHADA and harmonizing laws and questions of, the statute and what statute says in relation to treaties. But there's an underlying soft issue when it comes to enforcement. That's the attitudes of the judiciary. And we found that the huge shifts in our part of the world, just dealing with capacity, reinforcing the understanding in international commercial arbitration, and seeing how that translates to quicker enforcement at that level. The third one, I think, is to Tariq. So the trend, as you correctly pointed out, is this layered dispute resolution clauses, for mediation and a negotiation, mediation, and then you pointed at simplicity. I'd like to hear what that simplicity looks like, because I think practice is quickly emerging where that trend is being mainstreamed. What would the simplicity look like to avoid this overdue delays? Thank you.
I think by simplicity, I meant clarity. And the problem with some arbitration clauses when they're drafted by lawyers who don't have experience in arbitration or who are not aware of the risks of a poorly drafted clause, is that they are heavily affected by commercial interests. Obviously, two companies entering into an agreement, they'd like to preserve the agreement and they'd like to avoid conflict at all costs. So they keep adding layers, starting with mediation or consultation, and what happens when a problem takes place is that the claimant doesn't want to wait 60 days and then an additional month for a second layer of negotiations, and they go straight to arbitration. And oftentimes the award ultimately would have been issued in non-contravention with the terms of the arbitration agreement. And in some jurisdiction, that could be a ground for annulment. So what I would say, you have to be very clear in the arbitration clause. Like I've seen agreements where I've had both an arbitration agreement and a court, dispute resolution mechanism by courts in the same agreements, just two articles apart. So how do you interpret that? Do the parties want to go to court? It was probably a template that, again, non-practitioners took, threw in a clause here and there, and then ended up with an agreement that is non-enforceable. So I would say clarity and be practical about it. I mean, if you think as a party drafting an agreement that if the other party breaches, you will not be patient enough to wait 6 months to resolve the dispute, just don't put 3 layers, put one. One attempt at mediation, for example, or one attempt at consultation, and don't overcomplicate things. The mediation the consultation doesn't have to be between the CEOs of both companies. These are busy people. They probably have meetings all over the world, and they won't have time to meet within a limited number of days. So just make it simple and make it practical. You can have one officer of each company meet, enter into discussions. If it's not resolved within 30 days, then move on to arbitration. Don't add layers.
And if I may, I think you should avoid mandatory language, Because that when you have this sort of mandatory language, that's when a court or tribunal is going to have difficulty deciding whether or not someone has complied with that mandatory language. If you allow the parties, if you give them the option to escalate the dispute, etc., to court, because after all, if they want to resolve a dispute, they will find ways to resolve their dispute, and this making this mandatory is not going to make a difference except delay the process. But the problem about the mandatory language is that if you haven't complied with these steps in some jurisdiction, it means the arbitration is not admissible. And so if you want to avoid that fight, do not put mandatory language. And other things is do not get creative with the arbitration agreement. Don't put an arbitrator that has to have so many qualifications that you will end up with no one. Don't add a requirement that the arbitration be done in 6 months because this is impossible. And once the dispute arises, no one will agree to change that arbitration agreement. So sometimes the arbitration rules of the institution will give the institution the authority to ignore that and to extend the fact of the time limit of the arbitration, but often not. So when you have that, you basically end up with a pathological, unenforceable arbitration clause. So don't put yourself in this situation. Don't get creative.
Thank you so much.
Exactly. Stick to the basics. Stick to the basics. Matilda?
So thank you so much. We'll continue the discussion during lunch. We had more questions, and I'm sure you also have more questions for the panel. So thank you very much. Enjoy your lunch.
Thank you.
Thank you. That was fun.
Thank you very much, panel 6. It's lunchtime, but before we go for lunch, the announcements I've got for you, the students, UCT students who came here before to take the photograph did so, but it would appear some people photobombed, and so those pictures are now invalid. So you have to do it again. And of course, those of the program committee as well, you find time and do the pictures. We will have to leave this hall this afternoon, latest 5 p.m. So what I'm going to suggest is that we go for lunch. We had initially booked 1 hour, 30 minutes, but I'm suggesting that we take less than that time. We come back here as quickly as we can, namely at 1 o'clock or 1:15 latest, so that we can do the remaining panels, and then we leave here at 5 to come back at 7, because we don't need to make this hall, arrange it in such a way that when people eat, they can dance. I know that we've had cocktails the past few days and great food, great drinks, but we were not allowed to dance. Even though some people wanted to dance, they were not allowed to. There were no provisions for dancing. But tonight, there's going to be some dancing. So please space out yourself. And if you behave yourself, there will be more to the dancing anyway. So but I'll keep that to the end. So thank you all very much. Please try to be back latest at 1:15, so that we can kick off slightly earlier, so that we can finish the program on time. Enjoy your lunch. Lunch is at the same place like it was yesterday.